Welcome back. The legal battle between President Cyril Ramaphosa and Public Protector Mkhwebane seems far from over. Ramaphosa now wants the NPA to investigate Mkhwebane's conduct while preparing the report, accusing him of misleading Parliament over the donated funds from Bosasa. His legal team accused Mkhwebane of perjury. To discuss this further, we're joined by legal writer Aaron Bates. Aaron, thank you so much for making time. The president's plea is both bold and risky.
That's right, Clement, and the reason why is because he's asked the Constitutional Court to refer Mkhwebane to the National Prosecuting Authority. It's the third of the things he's asking of the Apex Court. The first is to dismiss her rescission application. The reason this is both bold and risky is because here we have three very powerful institutions of state. If we take the personalities out of it, you have a head of state asking the court of last instance, the most powerful court in the country, to refer the head of a Chapter 9 institution to the body which builds cases to prosecute criminals. It's absolutely astounding, bold and daring, risky stuff.
Yeah, so if the court does grant the president this plea, that would be quite a historic moment for the Constitutional Court. What does the public protector say about her rescission application?
Well, the public protector firstly says that this is not a backdoor attempt to appeal what is the decision of the court of last instance. And here there's almost a parallel with what we're seeing as former President Jacob Zuma too approaches the Apex Court to have a decision against him rescinded or effectively undone. The public protector insists that she really was trying to do her job, that she was basing some of her interpretation of the Executive Ethics Act on some of the decisions the Constitutional Court has made before. She referred, for example, to the Nkandla judgment and her understanding of what the duties of members of Parliament are when answering questions based on that decision. All of this is really poked holes into by the President and his legal team, but that's the basis on which she's seeking to have the court rescind its decision in his favor and effectively against her.
Yeah. In what circumstances can such an application be entertained, Erin? In other words, when can the court rescind its order?
So there are three different terms which are set out in the Uniform Rules of Court Act or the Uniform Rules of Court, and that sets out what courts can and can't do. And so here we have the three different rules under which a court can rescind, so effectively backtrack on its application. The first is if there has been an omission in terms of a party who is relevant to the decision. So if someone's been kept out of the loop and this has a direct impact on them, then the court may need to rescind its application. The next is been a material error of law. If there's some kind of an error or omission or fault really with the order or the judgment, there can be a rescission, but limited to that little issue. And the last one, if I can just remember my Uniform Rules of Court, is, let me just check my notes, Clement, I hope you'll forgive me.
Sure,
I have
no worries.
got a law degree, but I did make my notes on this. So this is when, yes, of course, there's a mistake to all of the parties. So this is something where it affects everybody involved, and therefore the decision needs to be reviewed and seen through and undone.
Yeah. Is this the only rescission application in which oral arguments have yet to be made before the country's top judges? I remember the former president, Jacob Zuma, has a case at the Constitutional Court as well.
Quite right, and that's already come up. So the issue here really, Clement, is looking at the arguments and the submissions of the president, which really are remarkable in how scathing they are of the public protector. He says that her rescission application is faulty. He accuses her through his attorney of perjury. His attorney has deposed to this affidavit with the endorsement of the president, and he goes into a slew of actions and decisions and statements under oath by the public protector, which he says really provide the grounds for her to go to the or be before the prosecuting authority and under scrutiny potentially for criminal charges. So the interesting thing here is if we look at the Zuma matter and the rescission application there is that one of Zuma's criticisms of the commission, the state capture inquiry's case, which landed him up in prison for 18 months, is that the commission didn't first go to the prosecuting authority over this contempt of court issue and didn't follow through the full procedure in the lower courts before running to the Constitutional Court Court and really ultimately getting Zuma behind bars. And so what's interesting here is that the president, in the matter of rescission with the public protector, a separate court case, has actually said the court should go to the prosecuting authorities. So there's an interesting sort of comparison, similarity and contrast between these two very high-profile, very politically charged rescission applications before the Con Court. And as you say, neither of them have we heard oral arguments as yet. It's all on papers, so journalists like you and me and other interested parties are reading through these reams of documents, but the action, the fireworks really will be when matters go before the bench of the Constitutional Court.